May I have your lordship's leave to mention a writ appeal for listing tomorrow, which is against an order which was passed on 19th of April. Unfortunately, even the order is not available. But we have filed a writ appeal, my lords, and we were having a stay till 19th. So therefore, Lord, grave injustice would be done if it is not heard.
What are you? We could not hear you. As well, I could.
Milord, there is a writ appeal which has been filed just now. Milord, I'm requesting, Milord, praying to your lordships to permit the registry to list it tomorrow, Milord. I need some urgent relief in that matter, because we were having a stay from February till now. We have challenged a government order dated 7th of January, Milord, which is actually going to, Milord, which is in violation of a treaty that was a treaty like a memorandum of understanding that was signed between the government of Turkey and
Where were you till now? You are challenging the government order January.
I was before the single judge where I had an interim order. My writ was dismissed only on 19th of April. So I had a stay order till 19th.
All right, tomorrow.
Please, oblige.
Tomorrow. If the
is in order, Milord, that is definitely there. If the
necessities are completed,
please,
the matter would be posted tomorrow.
Oblige.
Please ensure that if objections all that are there, they are removed. Because if the objections are not there, then the file is not sent to the court.
Milord, please, Milord, deeply obliged. Deeply obliged.
Start. Yes. Yes.
My lord, I am for the petitioner, my lord. My lord, I would candidly submit that there has been a delay in preparing the petition, my lord, over 3 years, my lord. The reasons has been explained in paragraph 2 of the petition.
Up to 6 years. Okay. This petition is last day petition.
Please, my lord.
When the courts are closed for summer holidays, vacation, before that, whatever is the kachra, that is filed. It is one of them.
It is filed earlier, not pursued. It came before the registrar and now it is posted. Filed because they have not moved it.
When did you file it?
In 2020, my lord. In 2020.
After 2 years.
Little over 3 years, my lord. I have explained. My lord, the delay I have explained in paragraph 2, the matter was not communicated as such, my lord.
You can argue whatever.
No.
Mr. Mahendra, what is there in anything is there?
So it's not a saved application, it was rejected. And statutory remedy is also not aware.
All right, we will justify your appearance.
My lord, I will, so far as is concerned, my lord, I would mention alternative remedy is not there. The power of the state is being exercised here by the respondent, my lord.
Revisional remedy.
Secondly, my lord, it is a saved application, my lord. The application is of 2011, my lord. May I submit, my lord? May I, my lord? It is a saved application for the reason, my lord, though physically the no objection certificates have not been issued or received in the office of the respondent, by deeming fiction under Rule 8(6), my lord, of the KMCC rules, it is deemed to have been received, my lord. This application is of 2011.
4 years.
Till 2000
any case.
till 2013, that provision was available, my lord. Rule 8, sub-rule 6 of Rule 8, my lord.
Today it is not there. That has been repealed.
2020 amendment.
Yes, sir.
Third, the notices for respondents have been taken by Learned AGA. The petition has been filed seeking following relief from the impugned order. From perusal of the impugned order 16/11/2016, it is very much clear that the which page? This is 1A.
Actually, yes.
Page 16 is the English version, my lord.
The application submitted by the petitioner seeking grant of quarry lease over an extent of 1 acre in survey 15 of such and such is not in consonance with Rule 8(b)(1) Karnataka Minor Mineral Amendment Rules 2016. As such, same has been rejected. The petitioner admittedly has approached the court after a considerable delay of more than 4 years, and even thereafter did not pursue the matter, as the writ petition remained pending in the registry and has been listed before the court only for the first time today. As such, the period of passing of the impugned order has been six years back. Learned AGA submits that the application preferred by the petitioner was not a saved application. Saved application in a single inverted comma. He is not entitled to claim the quarrying these. We do not find any infirmity or illegality in the order impugned, the writ petition being devoid of merit, as well as on the ground of delay.
Make one submission, my lord. My lord, make one submission, my lord.
Wrongly translated.
I may be, my lord, if I am permitted to,
8(b)(1). Yeah, write it 8(b)(1) where you are looking.
my lord, may make one submission, my lord.
This case law. I am appearing for petitioner.
Yes.
My quarry is granted on 26/4/2016 for a period of 5 years, as per Annex A, page number 13, Lord. Then, my Lord, before expiry, that I have made an application for renewal, Annex B. I have sought, my Lord, to consider, my Lord, Annex B and pass appropriate order. Annex B for renewal. That is filed, my Lord, on 4/20/2020.
Heard, the notices for respondents 1 to 4 have been accepted by Learned AGA. The petition has been filed seeking following relief. The counsel for petitioner submits that the quarrying lease granted to the petitioner dated 26/4/2016 shall be treated to be valid up to 26/4/2036, as it is deemed to have been extended for a period of 20 years from the date of grant, in view of deeming provision under Rule 8(A), again in bracket 3, KMMC rules, full stop. Learned AGA, appearing for respondents, on the other hand, submits that it will have to be verified as to whether the petitioner is entitled to get the benefit of the deeming provision or not. The competent authority, that is respondent number 4, will consider the case of the petitioner and pass appropriate orders in accordance with law. The writ petition as such, consent of parties counsel is disposed of with the direction to respondent number 4 to consider the case of the petitioner regarding the claim of benefit of deeming provision under Rule 95(9). 8A3 KMMC rules and pass appropriate orders in accordance with law within a period of 3 months from the date copy of the order is placed before him.
Implementation of the contract issued to the respondent number 7 by the respondent number 2 for widening of the road, my lord, NH 209 from Bangalore to Kanakpura, my lord, the petitioners have produced some photographs, my lord.
Who is petitioner? Who is petitioner?
The petitioner is a general public, my lord, who explained it in my first paragraph.
Just a minute. Who appears for NHI? Is there any counsel for NHI?
Shilpa Shah appears.
You, sir,
I'll serve.
the counsel for petitioner undertakes to serve the counsel for respondent number 2, 3, 4.
5 also.
5. The notice for respondent number 6 has been accepted. 5 by AGA. 6 by AGA. 7.
Agency, who has taken the contract? He is agency. He elected serve by handsome.
Issue notice to respondent number 7. Returnable at an early date. In addition to the regular mode, the petitioner counsel is permitted to take the hand notice to respondent number 7. Sorry, no interim order in PIL. This practice is only here. It's not your personal matter. If it is personal, then let us see that. List after reopening of the courts after summer vacation. 1 takedown is appearance for 1.
Much of council, my lord, matters pertain to mass encroachment of forest land in my lord, Raichur district. Road number 11, 34, 35, 32, and 33, my lord. Now, they are all notified forest lands, my lord. They have been encroached upon and by the response 9 to 29, 7 to 21. More than 8 acres of land have been encroached upon. With the support of the revenue authority, forest authority, lord, admit that they are the forest land.
From forest land.
Notification is produced at paragraph page number 39.
Who are you?
Lord, I have stated my page number 23. He is a progressive farmer, my lord. He has also worked, my lord. Page number 23, I explained, my lord. Paragraph 2 about particular petitioner. Lord, he was a progressive farmer and also worked in a central government sponsored project.
Studied.
The residents of Raichur, my lord, city.
Where you reside in that area itself?
Please, Lord.
Where do you reside?
I have decided in, my lord, in the village at Raichur, also in the city of Raichur. I have 2 houses, my lord.
How you are concerned about the encroachment?
Sir, the forest land, my lord,
Simply because you are a progressive farmer.
forest land, my lord, it's continuous process. They have encroached continuously, my lord, more than 8 acres of land.
Why this encroachment only? Why you are not concerned about the other encroachments which are being done?
But in respect of, my lord, the other survey numbers, my lord, some other authorities have put this on report, in petition number 611, 6711. My lord, the forest authorities have admitted.
He's staying in Raichur. He's not saying that.
The forest authorities have admitted, they connected another authority, acknowledged as
Near the forest.
authorities have admitted that, my lord, it's a forest land. A report was filed before this on report. But this is continued, my lord. All the lands which are for the entire forest will be destroyed.
The area,
At least paragraph 5, you can read out your locus that you have agricultural lands, your native place is Raichur, you stay in so and so place. This particular land is situated near your residence, and therefore you have public interest. That's what you have said in your. That's what we are asking.
No, it's about, my lord, I am about a notified forest area, which is a reserve forest area, and a notification produced. Lord, it's a reserve forest area. Reserve forest area. I'm not saying that it's a reserve forest notified land. It's protected under Karnataka
Reading is
Forest
there.
Act.
So
Section 35 is protected.
all right. The notice for respondent number 1, 2, 3,
5 and
7 and 8.
4 also.
No, man. 5, 7 and 8.
5 and
5, 7 and 8. Man.
7 and 8 shall be accepted by learned AGA. Copies of the resolution shall be handed over to him during course of the day. What about this 4, 6?
and private response.
Or a private.
Issue notice to respondent number 4, 6, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21. The PF shall be filed within 1 week. The list after service of notice in the month of July.
But I appear for stating before my learned friend commencement, I need to make one submission to your report. Lord, the original application is pending before KAT in respect of the same subject matter, where the unsuccessful candidates have challenged before KAT and it is pending. And my lord, there was notice passing has been ordered, and against which a writ petition has been filed before the division.
Correct. Is it correct?
Some unsuccessful candidate.
Have filed some case which is pending before the KAT.
We have filed before the Honorable Court, we are after granting interim order, again the matter is remanded to the KAT.
No.
They have revalidated the selection, initiated selection process by enacting a law, which is allowed by the Honorable Court by quashing a set in the.
No, sir, here validity is challenged. Where is this challenge?
What is wrong in the act only then? Act.
Constitutional validity of this act.
Kindly show what is wrong. What is
Appointment.
wrong in the entire act.
One submission. Against my lord, the issuance of notice before KAT. My lord, the unsuccessful candidates again approached before this honorable court in division bench, my lord, under KAT roster, my lord. The division bench said everything has to be considered by the KAT, and there is an order also of the division bench.
Can the KIT consider the validity of the act?
Yes, my lord, because of L. Chandra Kumar and my lord, subsequent judgment, my lord. Except the constitution of the tribunal.
You people can say anything. Huh? The validity of an act can be considered only by the constitutional court. Can a tribunal consider it? What do you people talk? Eh? This is it is not expected from you.
would upheld the other part.
No other court is competent to consider the validity of an act except the constitutional court, that is High Court or Supreme Court. That is why he challenged the act, and that is why we are asking that you have challenged the entire act. Now, what is wrong? You will have to first show how he is prejudiced by the act.
Prayer number B regarding annexure K, that is pending. That's what you are saying, isn't it?
Act also. Annexure K and G both.
Act. How can
Sure. No, this is a PIL. This is a PIL. Unsuccessful candidates have already approached the KAT. It shows that petition, application for the KAT.
successful? Then the PIL is not maintainable. PIL is maintainable when agreed persons have already approached PIL. Madam.
May I produce the order?
Sir, application before the KAT.
Application or the order sheet is there.
No, what reliefs they have sought for. Let us just see that.
If the agreed persons have already approached.
KT initially will not. So against the KT order, they approached the division bench in law. Division bench initially granted interim order and subsequently remanded back to the KT.
Sir, you have challenged annexure K. Sir, you have challenged annexure K. Is annexure K subject matter of
Yes,
the
my lord, I am appearing in that matter.
It shows that, no? Annexure K is official memorandum dated 22/3/2022. Just shows that that is pending before the KAT at the instance of the aggrieved persons.
With petition copy method of the coordinate thing that it is released on.
Entire selection process. No worry. Set up.
You challenge the virus, right? Please show us how the act is bad.
Actually, in the Arabak, some of them putting here. It's not.
Do you understand our query? Do you understand our query or not?
Yeah. Constitutional validity, I am challenging it not.
Hmm?
Just because
You are challenging the validity of the entire
they
act.
have revalidated Milan. The selection process which is initiated through a Arabak code is subsequently confirmed.
We are not concerned with all that. PIL can be maintainable only in case we are satisfied that this act, entire act is bad, not any particular provision. Because you are challenging the entire act, PIL can be maintained only in case you satisfy that this entire act is bad. No. Now, so kindly show that how this act is bad.
Reading to Lordships to page number 460, Milan. 460, Milan.
Yes.
Not withstanding anything contained in judgment decree of this tribunal authority contrary to the order providing justice given by batch, there are no fault hereby enacted the following. 2011 batch probationers select made the Karnataka Public Service grant all orders issued and so date the state government to withdraw the batch designated probationers shall stand cancelled. The state government shall take immediate steps to issue the appointment order by batch probationers. Karnataka Public Service Selection Lease. Willard, in the earlier public litigation, Willard, the government has withdrawn the selection lease by stating that Willard, they initially they referred this matter to CID Willard. So after getting the internal report from the CID Willard, they have cancelled the withdrawn this. And subsequently, the final report Willard, the KPSC members Willard, they have looked under section provisions of the IBC.
So what? How the act has become bad?
The illegalities, anomalies committed to KPSC is established in the CID report method, and subsequently the criminal action is taken against the KPSC members.
Therefore, the act will become bad.
The Honorable Court in earlier public litigation set aside all the selection process by passing all the notification. And subsequently, the Supreme Court is confirmed these orders without.
That will not render the act illegal.
But they are not assigned the cogent reasons to revalidate without.
So unless you
they have assigned only one reason, Milad, is subsequently in criminal cases, some of the members of the KPSC got acquitted. So that's the only reason they have assigned in this enactment, Milad.
No, we can't get into the reasons for the enactment. You'll have to show how the act is constitutionally invalid or violates any other provision of law. For us,
there may be several reasons. We are not on that. Once the act has been enacted, how it is bad, that will depend on its provisions, not the background under which it has come. And you are challenging the entire act, not any particular provision.
Next week, Milad. So I'll file some rejoinders.
We are dismissing petition. Or the notices for respondent 1 to shall be accepted by AGA, whereas you appear for Public Service Commission. Who appears for you? State. For the order proposed, the notice to respond number 3 is dispensed. This public interest litigation has been filed seeking following relief. Then the counsel for the petitioner submits that earlier the entire selection held was initiated,
was challenged
was challenged
for this court.
before this court in
WP
Number 13617 of 17.
13617-1362.
7 of 17
7.
and connected matters.
Take down from page number.
This is the operative. Page
But
number
445.
445. Operative portion.
The what happened thereafter?
Thereafter, they have done this colorable exercise of power.
It is alleged that it was thereafter that the respondents have enacted the Impugned Act in order to overcome the judgment passed by the High Court. Contention is that the enactment of the Impugned Act is a colorable exercise of power and as such is bad in law. We have considered the submissions and gone through the record. We are of the considered view that the entire act would not become bad in law simply because the earlier selection was challenged in the High Court and was quashed, and thereafter the Impugned Act has come in power, has come in force. The counsel for petitioner has not been able to satisfy, has not been able to show any provision of the Impugned Act which can be treated to be unconstitutional, illegal, or void. In view of above, we do not find any reason to grant indulgence. So far as the consequential prayers are made in the writ petition, suffices to observe that the aggrieved persons have already approached the Karnataka State Administrative Tribunal where their matters are pending consideration. As such reliefs are not required to be considered by this court at this stage. The writ petition being devoid of merit is dismissed.
For the weeks standing.
So there is a delay. Supreme Court order is applicable.
Huh?
Weeks standing.
Or what? Why you had filed the petition when you don't want to argue? What is wrong with the order?
Petitioner applied here in this auction purchase of lot, who had bought the property subsequent to that there was a defect in the title lot which could point out to the banker lot, and he sought for the rectification of that, or the same bank to be to advance the amount because the applicant was eligible for the loan lot. No other banks were ready to give the sanction the loan lot because of the defective title. The khata was a B khata milord, and the petitioner, the appellant him lord, he had given a representation in detail explaining the difficulty milord. That was also not considered. The writ petition was filed milord.
What is wrong here? You don't want to deposit the amount as per notice.
I would like to, but the title has to be a proper title. If I come to know that subsequently,
why did you
initially papers were not.
why did you participated in the auction, deposited the initial amount?
This was judgment, I'll get the judgment. That's the reason I sought for time, I'll get the.
I'm sorry, no judgment will help you.
Lord, what has happened is similar circumstances,
The
Lord.
learned single judge has said that the transaction is sale in auction, whether to sanction loan or otherwise is a prerogative of the bank.
That is one aspect.
Now, what is wrong in this view?
That is one aspect. Subsequently, there is one more issue, Lord, which I have raised, Lord. That banker has to
What if
identify the title and give.
he can give you liberty, go and approach the bank itself.
Please.
That is all.
Please.
This inter-court appeal has been filed. Challenging the order dated 11th of January 2021, passed in WP such and such. At the after arguing the matter at some length, learned counsel for the appellant submits that the grievance of the petitioner, appellant petitioner, would be redressed in case a liberty is given to the appellant petitioner to approach the bank and the bank consider the said grievance. In this view of the matter, this writ appeal is disposed of without entering into the merit of the impugned order, with the observation that the appellant petitioner may approach the respondent bank by moving a representation. In case any such representation is preferred by the appellant petitioner within 7 days from today, the respondent bank shall consider and do the needful in accordance with law expeditiously.
In view of Supreme Court order.
In the beginning, say the delay in filing of appeal is stand condoned in view of the Supreme Court order.
Number 7, KV 30. Yes, for KV 30. For 29 guntas, 55, my lord, only award is passed only in respect of 2.25 guntas and possession is taken only in respect of 2.25 guntas. Final notification is of the year 14/20/2001. Second notification was
BDA appeal.
21/10/2001.
They abandoned the acquisition. BDA appeal. Pending by.
All we should entertain.
Also,
No, sorry.
7A has no application. Sir. Delay in passing of the award has no application for as far as this is concerned.
Reasonable time. 2002 final notification.
Subsequently, Supreme Court has
Ask the order.
following the offshore holding has said that as far as 11A of the land acquisition has no application to the AID Act.
We will note the appearance of your senior and dismiss the petition. Because there is nothing wrong.
2002, section 19 final notification. No award even after the scheme has lapsed. The acquisition also has lapsed.
Yes.
Learned single judge has correctly said the acquisition is abandoned.
Now Brown is taken as saying that entire extent award is passed. What the BDA saying.
When is the award passed now?
Award
What is passed to an entire extent load on 28/11/2002, page Annex G, page 97.
finding of the civil.
Finding is wrong, is it?
Award is passed to an entire extent.
Possession is not taken.
Possession is taken to an extent of 2.5 for the Kunta on premises for the formation of the road which was urgently required at that point of the time.
Listing has not happened.
Correct. That's right. Only to an extent of 2 and
May I request your lordship to kindly take Annex
paragraph
G,
5. That's what that is the finding.
page 97.
Subsequently, it also noted that award was limited only to an extent of इतने गुंठा. जिसका परेशान लिया उसी का award है. परेशान जितने का लिया है.
That's what.
There is no further action taken regarding personal petitions with respect to any action right now. There is not any compulsion.
No, that's why we read this and said award is only in respect of 2.25 guntas.
97, page 97. So the entire.
This is factually incorrect, is it? This finding is factually incorrect.
May I make a suggestion, my lord? Your lordship may kindly take a page 115, my lord. My lord, initially award was passed in respect of 29 guntas. Later it was found that only 2.25 guntas is vacant, and in remaining 26 and 3/4 guntas, my lord, it is entire built up. As such, my lord, Deputy Commissioner recommends that award be restricted only to 2.25 guntas. The same came to be approved with the order of the
One second. There was an award for the entire extent. Then there was a supplementary award or a modified award.
modified as per the order of the Commissioner, my lord.
Was there a modified award?
Let us be clear on the facts.
Was the
If you-
award modified or simply an order is passed saying it is restricted?
Order is passed.
Then there has to be an award. We will examine. We'll examine it.
We'll have to-
Matter requires examination. Because factually, the finding on facts, the learned single judge seems to have said award is restricted only to
restricted.
2.25
Only on that
guntas.
premise the order has been passed.
Award is for the entire extent, but subsequent order of the commissioner says that only pay compensation.
Can the commissioner say that it is?
No, he can't say. He has to modify the award. Land acquisition officer, not the commissioner.
Then, but Commissioner of BDA can do anything.
No, he can't.
Deputy
Land
Commissioner, my lord,
Land acquisition
Deputy Commissioner passes an order, my lord, that award be restricted for only 2.25 guntas.
BDA, BBMP,
And-
Commissioner is.
And compensation is paid only for 2.25 guntas.
We'll examine. Shri CM Nagbhushan accepts notice for
Santosh Nagrale appeal.
Santosh Nagrale accepts notice for respondent number 2. Learned AGA for respondent number 1. A statement of objections to be filed within 4 weeks. Of list after vacation. No, but if you have not taken possession,
Possession is not taken, my lord.
don't create third-party rights. Respondent number 2 is direct. Parties are directed not to create any third-party rights over the subject land till the next date of case.
Delay requires to be condoned.
And condone.
Number 8.
Right. We are going to this, my lord, direction of issue to pay the penalty. Thereafter, they issue a direction of issue to repossession certificate and other NOC, my lord, to implement the project. Unless they issue a revised position certificate and NOC, my lord, I can't implement the project. Penalty was imposed, my lord, not to implement the project. Unless they issued a revised position certificate, I can't implement the project. During the hearing, my lord, when the judges expressed regard dismissal, then the petitioner counsel admitted that, my lord, let the use the time. On that ground, my lord, they sought the time, my lord.
No, this is based on, kindly come to page 17.
Yes.
Page 17.
Hey, that's what.
You have conceded.
Considered, my lord, after expressing that, my lord, they have no merit. Apart from that, my lord, still, my lord, I agree to pay. No, unless, my lord, they issue a possession certificate, first you pay the penalty and then implement. That was my grievance, in page 18.
You pay the penalty,
Yes.
they will issue clearance, they'll issue revise, everything they'll do.
Unless my.
You have agreed, no? For the learned single judge, you have gone and said that if 6 months time is granted, I will pay. Learned single judge has recorded it.
My lord, not an open court fixation. Yes, my lord, petitioner has said, my lord, yes, okay, my lord, let them give a time. He is not aware that, my lord, first I have to pay the penalty and then get the, unless they issue a possession certificate, I can't go to bank or I can't, no, unless they pay the NOC, I can't give an electricity connection as well as water connection. And my lord, unless give the possession certificate, I can't
You want some more indulgence, some more time,
Grant you.
go before the learned single judge and ask for extension.
Instead of
You
that,
want
will
some
give
more
grant.
time.
We
We'll
will
only
grant.
grant
instead of that,
time extension.
We'll
instead of
grant
that,
you
my lord,
3
I can-
months more
I can
time.
Directly approach to the board, my lord, and let them reconsider.
Mr. Patil is here. We can grant you more time to
I have agreed that.
pay the amount.
Yes. Anyway, let us not consider, then, my lord, let them issue a NOC. I can't implement the project. Unless I implement the project, I can't.
Sir, first pay penalty, sir. You agree to pay penalty.
Agree to pay.
You can observe that after payment of penalty, they will consider issuing of NOC.
Implemented the project. Building was constructed.
Nothing wrong. Take down.
Now, every, unless they issue NOC, I can't go to the bank and obtain the loan. And unless they give the NOC, I can't get the electricity connection.
Sorry.
Sir, penalty you pay, sir, first.
Penalty by
This intra-court appeal has
not
filed.
constructing,
All
not
right.
constructing the
All
building.
right. Here they are.
Pursuant to the interim order was provided to construct the building procedure. As per the interim order, I constructed.
We are here to test the validity of the impugned order. We do not find any infirmity in the order.
So far as pay the penalty and get the certificate, that grievance. Let them issue a clearance certificate.
Sorry,
And
Mr. That is not.
then I will pay
The intra-court appeal has been filed. All right. Now here the order.
permitted to approach the
Such and
court,
such
my lord,
ask-
for
Interpretation number such and such. From the perusal of the impugned order, from the perusal of the impugned order, we find that the counsel for the appellant petitioner had himself submitted that if 6 months' time is granted to the appellant petitioner to pay the penalty imposed in terms of annexure number A, same would be paid by the petitioner. Now the petitioner has approached this full stop. Now the petitioner, appellant petitioner has approached this court saying that the petitioner shall not be asked to pay the penalty unless the NOC is issued and the possession certificate is given to the appellant petitioner. We are of the considered view that the impugned judgment and order has been passed on consent of given by the counsel for the appellant petitioner and he cannot now say that he is not cannot say that he shall not be fastened with the penalty and first the NOC and possession certificate be provided to him, only then he shall be asked to pay the penalty. We do not find any infirmity or illegality in the impugned order. The writ appeal being devoid of merit is dismissed.
permitted to approach the board, my lord, but otherwise my time is already expired. The benefit of order is also.
That's why we said at the beginning, we'll give you some more time.
Sorry,
That's what my line.
we have passed the order on merit.
No, therefore I'm, that is, liberty me give to approach the tribunal.
Understand what you can get or what you cannot get. Sorry, next.
At least liberty to approach the board, my lord, let them consider merit.
You do whatever you feel like.
Let me say one thing.
Delay shall be condoned. Yes, next.
Objections. Also, there is court is delaying.
Regarding office objection,
Office objection.
along with the petition.
Yeah.
There are office objections.
They are
Annexure A1 and C1 description is not in writ petition. There is no averment of annexure A1 and C1 in the writ petition, though it is filed along with writ petition.
Yes,
Not relevant.
11 is.
11 is sketch, but annexure A1 and C1 not relevant for disposal of this appeal.
why you have annexed?
But they were part of the original writ petition. That is the reason we have.
All right, yes.
Same yesterday's orders. That 11 is sketch.
Yes.
ये order कर दो फिर।
Same thing.
The office objections are overruled. And pass this order. This order is to be passed
Please, my
yesterday.
Yes.
Any change in date?
lord, it is connected. 57 of 22.
Is there any change to
No,
be
my lord.
made regarding dates and all?
Dates, my lord. Petition number and
Afterwards, we will not make any correction.
order dated 10/11/21. WP number
Same order.
19594 of 20. Delay and protected.
Delay to be condoned.
4 days delay. Number 10. Before the appellate.
Family court matters.
Maintainability of
Writ appeal not maintainable. Family court.
we also not paid.
That is why.
During the pendency of the writ petition,
Actually, court fees been there. They know
during
it.
the pendency of the writ petition, not certain events have taken place where the Milord husband appellant had
A
lost.
writ appeal
Therefore,
against family court
family court.
not maintainable.
No need
Therefore, I say
to
to you,
go ahead. That judgment.
741 of 2016, whereby the said petition filed by the appellant dash husband was dismissed by the learned single judge. Full stop. The registry has raised an objection regard to in view of the
full bench
decision of the full bench of this court in the case of so and so ILR 2009 Karnataka 1-2-2007. Writ appeal is not maintainable. The same is accordingly dismissed.
review of the sample court seek review of the order because certain events which have taken place during the pendency
They have
of
not
the-
restrained you. We have not restrained you. We have dismissed the appeal being not maintainable.
Present appeal, not additional documents have been produced to show that not the husband had lost employment. Unfortunately, not that was not brought in notice of the learned single judge.
Next. To deposit the court fees.
Please, I'll activate the course of the case.
Beginnings say that the deficiency of court fee shall be made good by the appellant during course of the day. The counsel for the appellant undertakes to make good the deficiency during course of the day.
11, Vivekananda TP.
Story of Nuts. That was the contract. Respondent that was the contract. Respondent plaintiff nut has raised 3 bills nuts. Value of
50%.
50%.
50%.
If you deposit 50%, we will entertain your appeal.
Decretal amount.
The greater number. Quickly, otherwise you will lose this opportunity also.
50% of the nut, the suit claim nuts.
No, decretal amount. Third, learned counsel for the appellant and peruse the matter on record. In addition to elaborable, learned counsel for the appellant submits that the commercial court, commercial court committed grave and serious error in not considering the entire oral and documentary evidence on record, as well as the pleadings of the parties, and this has resulted in erroneous conclusion. And the matter requires to be reconsidered by this court. Said submission is placed on record. Appeal is admitted. Issue emergent notice to respondent. Registry to secure the TCR. Full stop. Meanwhile, on IA number 1 of 22 for stay, the operation and implementation of the impugned judgment and decree stayed subject to the appellant depositing the decretal amount within a period of 50% of the decretal amount within a period of heavy amount is there.
4 weeks.
4 weeks from the date of 4 weeks from today. 6 weeks from today.
I am for respondent number 3 in this case, my lord.
So the work of this is the portal matter. Work order is issued yesterday. Work order is issued.
issued a they issued a letter of intent or a provisional work order to us yesterday. Now, my lord, this from the last 4 to 5 days, daily negotiations on the pricing have been going on. In fact, the price that they have given the provisional order is not taking into account the methodology of putting the machine. That is the pothole filling pipe machine. My instructions are.
Let's look at the order.
Yes.
Oh, is there any rate
Yes.
for the work to be done by the machine?
Yes, my lord. My
The
lord.
government.
Yes, my lord, by the government, may I pass on the common schedule of rates which the government for the.
Oh, we will not go into detail at what rate they have to. The only thing is that at the rate fixed by the government for the work to be done by the machines,
Yes.
that rate should be given.
That rate,
Not
that
the
is
rate
all.
in my
That
submission.
rate, we have given. That schedule of schedule,
That's
current schedule rates.
not the manual.
No,
Not manual, the rate they have put, my submissions are, my lord, that the rate, though the work is set to machine.
Kindly from the government schedule,
Yes.
show what is the rate
Yes. That
for the
pass-
machine.
May I pass on the government common schedule of rates?
No, please don't pass on to us. Just give us the rate at which the government has fixed for the machine.
Has fixed a specific hourly rate for the pothole repair machine at 1249 rupees an hour.
1, 2.
1249 rupees an hour. In fact, the company's managing director is also here. 1249 rupees an hour.
1249 rupees per hour.
Per hour for pothole repair machine. That is as per the government schedule.
Yeah.
Now, my instructions are, my lords, is that in the rates they have calculated, it is a complex calculated amount. This per hour rate of the machine is not at all included. And in fact, we gave them a representation yesterday that you have to put in the rate as per the government schedule of rates of the pothole repair.
Kindly pass on the work order.
My lords, this is the
क्या मुश्किल है यार।
my lord, this is not for the courts to get into the nitty-gritties of the commercials.
Purely on this public interest of getting the proper roads in Bengaluru.
Because the whole,
Now,
we were only brought in
planning to be
in the work order, my lord, only a lump sum rate is been put per kilometer.
Yes,
This
Mr.
calculation is not clear.
No, do you dispute that the rate as per schedule for the PWD?
Yes.
This is what they are asking.
Yes.
You are not ready to pay.
No, we are ready to pay for the schedule of rates that we have. Yes, your lordship,
Which schedule you have got?
not unit per hour. Per hour is what they are asking, my lord. Per hour, they are expecting us to pay 1,249.
This is what has been provided by the.
Lord, this is only for like an ambulance, my lord. When we, for example, immediately we need something done, then we are paying hourly basis.
But this is a year contract, 2 years contract. If I start paying for 1 hour, every day 24 hours, kindly see the amount, what will happen. What is made submit? Manually, we need machinery. In this case,
is there any rate fixed for the potholes to be?
Yes, my lord, there is. Yes, my lord.
By machine?
Yes, my lord, there is.
That is the
There is.
rate. Per hour is the estimate. We don't charge per hour. We will give it for per day, 8 hours of machine will be functioning.
Well,
In
that
fact,
is
in our
per
letter, we have
day.
one machine. In our letter, we have given a calculation on the second page of our letter dated 19/4 that how we calculate one pothole machine.
Earlier, how you were doing? How, at what rate?
Because these guidelines are recent. Earlier, there were
No, no, no.
machines.
This is not that.
Kindly,
How can we?
let us imagine
now
the amount that we will be
Ask
paying.
you to consider this.
Please try to understand. Now you want a contract for 5 years and you will charge per hour.
We are not
Can
charging.
it be
We are
even
not
thinkable,
charging
my lord?
per hour. We have
I fail
given
to
a
understand.
rate taking into account the methodology. of
Let's
the
understand,
My lord,
these rates are for what?
these rates are work like an ambulance, my lord. Urgent need is there, then we pay hourly basis.
One second. No, 1 second. Are you saying pothole reparation is like an ambulance? Preheater unit is like an ambulance. Pre-stressing jack is like an ambulance. Ripper is like an ambulance.
My lord, these
What are
are
you saying?
these are, my lord, when we need urgent machinery, urgent road repair work.
The entire equipment
Yes,
machinery mentioned in this list is emergency based.
Let's kindly see 111, 112, 113
That
per kilometer.
shall take into consideration.
My lord.
Where do you get that?
No, this is
We have not produced the entire.
No, I have
My lord,
not
kindly
produced the
see, my lord,
entire-
if I start paying 1 hour, per day, even if it is 8 hours.
If government has fixed, if the government has fixed it, you will have to pay.
Srinidhi,
This is
per
not.
T kilometers is emergency. Just look at that schedule.
But if the government has fixed it, you are nobody to doubt it.
How can this be called emergency?
If that is the rate fixed by the government, whatever rate has been fixed by the government, you pay it.
estimate for an hour based on.
This
which
can't be
you
called
calculate
emergency. Look at it, logically think about it, and this be called as emergency rates.
But I asked this question to myself. How do I know how much
You
machine?
don't decide, let us decide based on
Oh,
government.
you have
rates.
got sufficient staff to verify as to how much machine has been used.
May I?
If the machine has used for 1 hour, you will have to pay for 1 hour. If the
Okay.
machine has been used for 8 hours, then you pay for 8
How do you
hours.
say this is not applicable?
Because that is what the government says.
My lord, I'm sorry, I have only one copy, but I will produce it. There is a SR for manual repair work and mechanical.
No, manual we will not permit.
Mechanical is here.
Mechanical, you do it. Whatever is the rate.
For earthwork, if it is manual, it is 452 rupees. But if it is mechanical, it is 327 rupees.
This is the work order. Let the work be started. So far as the rate is concerned, we direct the chief commissioner to
We hire the machineries. Here we are giving a contract.
What we will do is that since you have already issued the provisional work order, we will record this, take into consideration and tell them to start the work.
Yes.
On the basis of this provisional work order. So far as the rate is concerned, we will direct the chief commissioner
Yes.
to resolve this
Yes.
issue,
Yes.
taking into consideration this government and they shall be entitled to get the payment on the basis of this.
The Lordship may not say on the basis of that, because we also are relying.
Oh, this is approved by government, what we are not.
Also relying on a common rate approved by the government. We place that also. Let the chief commissioner have both of them, my lord. Because my instructions are, these are for hiring machine. Here I am giving a contract. Kindly, my lord, allow the chief commissioner to place both these SR rates and let him pass it on. And place it before your lordship.
No, not that. I'm sorry. There is a schedule of rates which published by the PWD. Government of Karnataka has accorded it. Let him see both of them.
Then what is this? This it only says common schedule of rate. It is not that for some emergency or urgent.
No, that entire my learned friend is not produced. I'll produce it. Your Lordship, I direct the Chief Commissioner to look into both this and pass an order.
Which is the other one?
Because we have PWD, we have, I just produced, I have this. This is chapter 1 like this. The same thing, chapter 1, we also have this. We are relying on this. They want to rely on that.
So that is why we will have to resolve it.
Yes, madam. Let the Chief Commissioner look into both of
If the
these.
Chief Commissioner resolves it, then one more writ petition or one more application here.
More writ petition, but your Lordship may kindly direct it to be placed before your Lordships. Your Lordships will decide. No writ petition. No further litigation.
Now we want the work to start.
Let the work start, madam. This will be resolved. This will be resolved.
They will not start the work unless you finalize the rate.
But we will finalize it in 1 week, madam. 1 week we will finalize it.
How can we ask them to start the work without getting any money?
My lords, earlier they relied upon the same calculation what we have done. Now they are coming on this. Let the Chief Commissioner decide, my lords. I'm seeking for 1 week time. Because my lords, earlier they already have 200.
Whether the Chief Commissioner has considered this or not.
My instruction, 1 minute. My instructions are here. They have a meeting together with the ACS UDD as well. Both of them have sat on this. They have given this calculation. But if your Lordship direct,
it is the common schedule rate for the normal working.
Commence the work. Let them pay upfront some money and let the work commence. After vacation, we will let both of them.
In the meantime, let Chief Commissioner decide.
Let him not decide. Let him give a
report. Let him submit a report. We can take into consideration this.
If he decides, then it becomes an order. Then somebody we have to sit over it. Instead of that, let both give
take a decision and place it
take a decision.
And place it before the decision.
Let the chief come to ensure that the work starts immediately. Let the chief, you submit your representation. Let the Chief Commissioner look into your
We'll take into consideration this. You say that it has not been considered, and take a decision which will be placed before the court on the next
then
day.
we'll discuss.
And
In the meantime, commence the work. To commence the work, what more do you want?
Ready to commence the work. Right now, the orders given are for the major roads. These are the major roads, which are the larger roads. They're ready to commence the work on the major roads. The ward roads, which are more tricky and smaller, they would like to wait till the price is confirmed, but the major roads will immediately.
This itself will take some time, isn't it?
yes, yes, madam.
Major roads will immediately.
No, immediately meaning before end of May, it will take time up to the end of May at least, isn't it?
182 kilometers. Major roads are 182 kilometers.
So let them start the work. We'll post it immediately after vacation. And then in the meantime, let him take a decision with regard.
Mention that the decision on this also.
So we'll
Yes,
record your
yes,
submission. We'll record your submission.
That we will
his
direct.
submission, and then say the Chief Commissioner will take a decision.
Before my lord.
Yes, yes.
So that if any, if it's not considered, my lord, we have.
No, it's my submission, my lords. That will be adjudicated by your lordships.
All right. Take down. Heard. Srinidhi, counsel for BBMC, submits that pursuant to the in compliance of the court's order dated such and such last order, the provisional work order has been issued. Work order dated 20th of April 2022 has been issued along with letter of acceptance. Full stop.
On my lord, for 182 kilometers is for the major. Not the other.
Which is for the 182 kilometers of major roads and selected ward roads of West Zone in Bangalore city. Full stop. It is submitted that the BBMC has provided the rate which is much below the scheduled rate prescribed for the work of repair of potholes by machine by the PWD. The respondent shall be entitled to get the rate which is prescribed for the PWD. Full stop.
Pothole repair machines.
For the pothole repair machine.
Serial
Full
number
stop.
94 of the volume 1 of the PW.
In this regard, the counsel for respondent number 11 has placed before the court Government of Karnataka Common Schedule of Rates, Technical Working Group, Volume 1, in which at serial number 94, the prescribed rate for pothole repair machine is rupees 1249 per hour. It is submitted that respondent number 11 is ready to immediately start the work at the prescribed schedule rate as noted above. Mr. Srinadhi, the counsel for BBMP, submit that the aforesaid rate of rupees 1249 per hour for pothole repair machine is for the
Higher charges, not contract.
huh?
For the higher charge, it is for the higher charges. When we hire the machine, it's not for a contract.
Is for the emergency purposes, and that is not the scheduled rate.
Yes.
Full stop. We have considered the submissions. We are of the considered view that the respondent number 11 shall immediately start the work of repair of potholes as per the work order dated 20th of April 2022.
On major roads, your Lordship, on major.
For the major roads.
There
So-
are 3 work orders. Which of these?
For the
First one,
for the
A,
major roads. Sir.
A and type. Mentioned as A, my lords, package A, mail.
Package A.
Right.
The slide, package.
For- In bracket package A, the Chief Commissioner BBMP is directed to reconsider the rate at which the payment for repair of pothole by Python machine is to be made by taking into consideration the schedule of rates fixed by the government of Karnataka for PWD, including the schedule of rate placed before us, which prescribe the pothole repair machine rate as 1249 per hour. Rupees 1249 per hour. The
report and decision of
the decision of the Chief Commissioner BBMP shall be placed before the court on the next date.
as well as status report by respondent number 11.
The progress of work report shall also be placed before the court on the next date.
By the 11th respondent.
By respondent number 11.
In the meantime, in case the respondent make a request for payment of any advance to start the work, the same shall also be considered by the respondents and
By the BBM.
by the respondent BBMP and appropriate action shall be taken in this regard. List after reopening of the court.
Date last week of May.
31st May. Point number 8 is not served in this matter. Minor irrigation. Number 8.
No problem. Next time.
PL rules.
And for respondent number 10, my lord, in this case.
Report is filed. Learned AGS submits that as directed by this court on the last date of hearing, the state government has filed a report dated 16/4/22. So the report is placed on record. Full stop. Learned counsel for the petitioner and learned counsel for the other respondents seek time to go through this report and make submissions in this regard.
Office objection.
Office objections to be made.
Update is filed, again, office has raised small objection, complaint.
You make good the office objection.
Be made good by the next day, within 2 weeks from today. Released in June. July, sir. July.
1:30 बजे आज बाहर में जाना है। उसके बाद करना है।
Number 1 and 2 are not served with notice.
2 weeks to do the needful.
Next. Who appear for respondent? Nobody is here. Nor any name is shown. Can we hear them? Hear you up? Ex party. Copy serve करा देंगे council को then सुनिए. Serve
Please
the
serve
council.
copies. We'll take it up immediately after vacation.
Serial number 16,
Nobody
my
has
lord.
put in appearance. No name is shown.
My lord, serial number 16. I am for the respondent, number 1.
Item 15.
Item 15.
It is one prior to that.
Sorry, my lords, I apologize.
You serve the council who appears. We can give you liberty.
Mangalore City Corporation. Anybody appears? Harish Bhandari.
Counsel for petitioner is permitted to serve Harish Bhandari, who is said to appear for respondent, Bangalore.
Both of them. Both respond.
Both respondents. List immediately after vacation, summer vacation. Can't pass any order.
Milord, 16, I appear for the appellate, Milord.
I am for the respondent, number 1, my lords.
Milord, this notice to respondent 2 to 4, Milord, who are residing outside the country has already been taken. May I pray your lordship permit me to take notice to the council who appeared, Milord, in addition to the notice which I have already taken, Milord.
He wants, but council may be a little difficult.
Who
Disposed
appears?
of matters. So
Milord, I appear for the appellate in this case, Milord.
Party है भाई.
no, we can't.
Session how can
Disposed of matter, we can't take it.
No.
Milord,
He may not be authorized. How can you serve him?
Milord,
Is it disposed of matter?
Milord, they are residing abroad, Milord. I have taken steps, then the notice will have to be awaited, Milord. I have already paid the process, Milord.
2 weeks to do the needful.
Milord,
List after service of.
please.
Next.
The disposed of matter. This matter, lordship, I have filed an IA. The petitioner before your lordship had filed a petition against me, Lord, and the order was obtained by representing that there are guidelines against the migrants who come and get caste certificates in the particular state. And after obtaining that order, Lord, he realizes that there are no guidelines prohibiting anybody from getting a caste certificate. And then he files a PIL before your lordship without disclosing that he is the petitioner in my case, abuses the process of the PIL jurisdiction of this honorable court. And same respondents, except me, Lord, Karnataka University is the respondent in the PIL, state government is the respondent in the PIL. He files a private petition just because that order is stayed and it is inconveniencing him in the writ appeal. He files a PIL without disclosing that he has filed a similar, not against me, Lord, he has filed several such complaints, petitions, representations to all.
We have not done anything.
Correct, Lord. But he should have known. The issue is, Lord, to gain credence that I am a bona fide PIL petitioner, so guidelines may be issued, and there are no guidelines. If there are no guidelines, he represents for your lordship that he has no public personal interest in the matter. He himself is the beneficiary. Now, Lord, I question myself. I file a petition. I am personally interested in this matter. I come and file a PIL, also get some order here.
What is this IA?
IA is, my lord, for necessary directions bringing to your lordship's notice that such abuse of the PIL jurisdiction is being made. He is a petitioner, he files a case against me. And in the writ appeal, it is stated he files a PIL and tries to get an order from.
Cost.
That order passed by us, though there is no adjudication at all.
Yes, I follow.
No, this order affects you, is it?
It is, my lord, a misuse of the abuse
Right,
of.
that we understand.
It affects in this sense, my lord. It affects in this.
No, does this order affect you in a little bit?
It helps me in a way. I submit, my lord.
What do we do? We can't pass. You are not a party to the petition, so we can't. The registry has said your IA is not maintainable. If you want any modification or if you want us to impose cost on him,
yes.
If you want us to do anything,
then you will have to file a review.
You have to file a review.
I have to impede myself and
Review is review by a person who was not a party is maintainable.
Yes.
Now, if he is aggrieved,
yes.
So a agreed person, even not a party, can file review.
You
can file a review if you are aggrieved.
Yes, but
But
pending
this
that,
IA is not maintainable.
I bow down, my lord. I'm only an informant before your lordship. I may be treated as an informant before your lordship. I will file a review petition, my lord. I bow down.
What to do? This happens every day.
Abuse me.
How long will we burden ourselves by being informed?
Petition is filed, my lord. Again, they file a PIL here. And luckily, my lord, lordships pass an innocuous order. Lordships have said just within the guidelines.
You only given
Correct. That is, my lord, a luck factor. Now, suppose your lordships had gone into the petition, awarded him some relief, and I have not seen the writ petition, my lord. That is camouflaged as a PIL. I go down, my lord. What I am an informant. Whatever I am at your lordship's hand. Review, my lord, pending that lordship may keep.
Right. We are doing that. Yes.
IA number 1 of 22 is filed by the applicant seeking directions, seeking necessary directions in the present petition, which was disposed of by the final order dated 30/3/2022. Full stop. A perusal of the affidavit in support of the application will indicate that the applicant has inter alia contended that in the above petition, the writ petitioner has suppressed several material facts, isn't it?
Yes.
And as such, the said order, which was passed without the writ petitioner disclosing material facts, is incorrect and is incorrect, and as can be seen from the averments and made in the affidavit and the documents produced by the applicant. Full stop. Having regard to the various contentions urged by the applicant in the application and affidavit and the documents produced by him, without expressing any opinion on the merits/demerits of the contentions put forth in the application, we deem it just and proper to dispose of the application, reserving liberty in favor of the applicant to file an appropriate review petition/recalling application, review petition.
Yes,
in case he feels aggrieved, subject to the aforesaid liberty.
Right.
Right. Where is the section 34 award order? Two? BHL is allowed, your suit is dismissed. BHL suit is allowed, petition under section 34 is allowed. Seems to be wrong. Revision notice. Should be right. No, intermodal are not sought, right? Right. Third, learned counsel for the appellant issue notice to the respondent. List after service of notice.
So the MRI machine is finally working, and we carried out the first MRI last night. There's a lot of trial runs are going on, but yesterday we did the first run.
Where is the report?
MRI.
No, not MRI.
I filed in after yesterday with the documents. Has also the photographs of the machine. I also have the print also not has been appointed.
What remains? What remains?
I thought it now be closed. So far as
Anything remains in the writ petition?
The appointment, that also one person you appoint.
yes, that's a medical superintendent.
That's enough. I mean, that's sufficient compliance of all the earlier orders.
The public interest litigation has been filed. In the beginning, right, Naveen Raj Singh, Principal Secretary, Health and Family Welfare, in bracket, Medical Education, Government of Karnataka, is present before the court. This is there. Public interest litigation has been filed. Following relief. Take out the relief. During pendency of the writ petition, directions were issued to the respondents regarding the installation of MRI scanning machine at PIMHANS. The installation of the machine was required as per the respondent themselves, but for one or the other reason, it could not be installed. First off, the compliance affidavit has been filed. Dated 20th of April 2022, stating therein that installation of 1.5 Tesla MRI machine is complete and working, and trial runs are in progress, and further the appointment of medical superintendent to Dimhans has been completed, and Srimati Dr. Saraswati N has been appointed. The above compliance is substantiated by production of letter dated 19/4/2022, along with photographs of installation of MRI scan machines and appointment order of medical superintendent, which is on record. In view of above, we feel the substantial compliance, we feel that substantial compliance has been carried out and by the respondent, and nothing remains for the court to adjudicate the writ petition, which is finally disposed of.
Supreme Court directions, my lord, this petition has been initiated.
Sumoto
Legal services.
PIL. The beginning is right. The Sumoto PIL has been registered pursuant to Honorable Supreme Court's directions. It is 5995. Order dated 5995 on reproduction results under this flag.
Order regarding withholding of salary.
No, that we had.
Last time we had.
Also, of disposal of
That we have to say. We have to say that. Otherwise, today it's in abeyance. We have to say that.
So that all
Order.
merges in this final order.
Better to say clarity.
See.
Restraint on disbursement of salary is hereby
In view of above, the restraint on disbursement of salary of the principal secretary
shall cease to remain in force.
shall not be given effect.
Shall not be given effect.
Service tax and ancestral payment of
Yesterday we have passed some order. Yesterday also we have passed some order.
Service tax on royalty.
What order we have passed yesterday?
We have stayed it. We have stayed it.
Same order. The proceeding. So what remains?
Nothing. Just to file objection. Sri Jeevan Niralgi accepts the entered appearance on behalf of respondent number 4. Statement of objections within 2 weeks. List after vacation.
I appear for the third respondent in the first matter, my lord.
My lord, in the connected matter, my lord, I appear for the petitioner.
Mr. Madaran Pillai, next time we don't come physically, we won't record your presence.
No, Supreme Court has also stopped
Yes,
virtual hearing.
after vacation, I think today also it is stated.
After taking permission, that is permitted.
This particular gentleman never has not seen him once also.
I may be excused today, my lord. After vacation, I'll be.
We will also stop virtual hearing.
Yes, my lord.
Because it is
Name is already shown.
pain in neck.
Yes, my lord.
Yes.
So for third respondent, my name may be.
Senior advocates come to court, and you people being young don't come to court.
No, I'm all.
Including application 20.1.
Semi-kindi.
21.
Its objections, my lord, including the maintainability of the writ petition against the NGT order.
an IA for amendment.
As order. You have not complied the office objection.
Already complied with all the objections except in regard to maintainability of the petition. With regard to maintainability of the writ petition, Your Lordship, last time itself I had made a submission. Based on that, Your Lordship has directed me to amend the writ petition. So I filed the application for amendment.
All right. Accepting the reasons stated in the application, IA number 1 of 22 is allowed. Petitioner to carry out amendment and file amended petition within 2 weeks. List after.
There is some urgency matter.
It will come, you move it after vacation. Meanwhile, office objections to be complied with.
Complied together, no?
Learned counsel for the petitioner submits, office objection has already been complied. Registry to verify.
Submit report.
And submit a report.
Number 22.
For the fifth respondent. For a 2 weeks time, to file a statement of objections.
You appear for respondent number
5.
Counsel for fifth respondent, press for there are 2 weeks time to file this.
7, 12, and 14, my lord. My name is shown only for 7, my lord. 12 and 14 is.
So the name of
Chetan.
Shall be shown as counsel appearing for respondent number
Including 12 and 14. 7, 12, and 14.
7, 12, and 14.
Number 23. Gauri Shankar has 14%.
Sir, Gauri Shankar, party in person.
Yes.
The opposite side advocate has to give their objections, sir. That is today's agenda.
Hmm?
The opposite side advocate, they need to give their objections from BBMP. Mr. Srinidhi, I already informed him, given the case papers also, he has to give his objections, sir.
Kindly see the prayers. No representation has been given to the BBMP before filing the petition.
I've given the representation, sir. I've sent an email to them.
What is already in case, Lord. Case 48. The petitioner is seeking, my lord, that we should not, even if there is insufficient document, we should not reject the kata.
That is the rule, sir. That is the rule. Rule 4 of Sakala Services rules state that if the documents are insufficient, they have to mention the applicant that the documents are insufficient. The same thing happens in this court also. When I filed this PIL, some papers are not correct. They didn't reject it. They gave me time to rectify the defects. And there's a newspaper article, media article, which came last month, where Ms. Mamta Madam, she's an IAS officer, she has specifically mentioned that if there is any document shortfall, they have just 2 days time to mention that to the applicant. If the 2 days time has passed, she says that it is deemed to be accepted. This has come in the newspaper from the government officer itself. And I'm just quoting what is there in the rules. Rule 4 of Sakala Services rules.
Representation, so let him submit a representation.
We can dispose of this, giving you liberty to move a representation, raising your grievance. That would be considered.
Sir, this is the clear violation of law.
Was seeking a mandamus without making a representation to them. So that is the first requirement that should be fulfilled.
Sir, I did that, sir. I met those officers multiple times in their offices. I went and met them. I sent an email to them. I gave them all
when
the
you will do it in compliance of the court order along with the copy of this order, then they will act on it. We'll direct them to decide it within a time bound manner.
But please consider that I have
public interest litigation has been filed seeking following relief. Srinidhi, appearing for respondent, submit on the basis of instructions that the writ petition has been filed without making any representation to the respondents. Full stop. In case any such representation is made, the competent authority will consider the same and pass appropriate orders. Full stop. In view of above, the writ petition is finally disposed of with liberty to petitioner to raise his grievance by way of a representation within a period of 10 days from today before the whom?
To the head legal cell, BBMP.
Huh?
Before the head legal cell, BBMP.
That is you.
BBMP.
Sir, if they don't act on this, sir, if they don't act on this, can I file a petition once again, sir? Because this is really
You will
hurting.
decide.
Okay. Because I met them, gave them letter, got their office acknowledgement, I did
The
everything.
commissioner.
Well, let it be head legal settlement, because if it goes to commissioner, then again it has to come here. Let it be direct. There is a wing of legal advisors.
Whether the head legal cell is competent authority.
But he will, end of the day, commissioner will sign it.
Look into it, put up a note.
So then commissioner has to decide. No? Before the commissioner, BBMP, in case, what you are written, giving liberty to petitioner to move a representation within 10 days before the commissioner BBMP for a stop. In case any such representation is made along with copy of this order, the commissioner BBMP shall consider the same and pass a reasoned speaking order within deciding the representation within a period of 8 weeks.
I request your lordship to mention written representation, because they've sent an email. Get thousands of email. Written representation.
Definitely, I'll do that, sir. I did that last time also.
Written representation within 10 days.
Because I met those officers, I spoke with them and all.
The same shall also be communicated to the petitioner.
24 to PR Srinivas Gowda.
My lord, I appear for the petitioner, my lord. My lord, I appear for the petitioner.
Yes.
My lord, the second respondent, deputy commissioner has granted 20.
Madam, please turn your mobile. If you're on mobile, please turn it around.
Yes.
Clockwise. Right.
No.
That's right.
My lord, deputy commissioner, second respondent had granted 20 guntas of government land to establishment of solid waste disposal unit, my lord. Near to that land, Aisur Hole river is flowing, my lord. That river is main source of water for drinking water for villagers as well as for the wildlife animals also, my lord. Because that area is situated in Western Ghats of Uttar Kannada district, my lord.
There is land is granted for construction of landfill.
For disposal of residential hospital waste without following the
Grievance is that there is a stream nearby. They have given representation.
Let that be considered.
Only grievance is that water stream is there. Only grievance that water stream is
All right. We will dispose of saying representation.
Similar matters, my lord says directly deputy commissioner to look into that.
Consider.
Grievance,
In this petition, in this public interest petition, PIL, the petitioner is sought for the following reliefs.
It's not PIL,
Not
it's free
PIL.
petition because
This petition,
Naroda bench it is.
Petitioner has approached this court seeking
following reliefs. Third learned counsel for the petitioner, learned AGF for the respondent, number 1 to 3, and peruse the material on record. For the order proposed, notice to respondent number 4 is dispensed with. It is the grievance of the petitioner that the impugned order at Annexure D, dated 10/5/2021, granting the subject land for the purpose of landfill for disposal of residential and hospital wastes is done without following the guidelines under environment laws, and despite the petitioner and other residents submitting written representation dated 22/9/21 and the president of the Wajagod Panchayat writing a letter dated 11/10/21, apart from the fact that the deputy Tahsildar along with the revenue inspector visiting the spot and drawing a panchnama stating that there is a stream nearby, the respondent number 4 is proceeding to use the said land to construct a landfill site. Full stop. Having heard the learned counsel for the petitioner and in view of the aforesaid facts and circumstances, we deem it just not appropriate to dispose of this petition, directing the concerned respondents to consider the aforesaid representation, letter, as well as the Panchnama referred to supra, and take appropriate decision in this regard with regard to usage of the subject land for the purpose of construction of a landfill in accordance with law within a period of 3 months from the date of receipt of a copy of this order. Liberty is reserved in favor of the petitioner to submit additional representation to the concerned respondents, who shall also consider the same in accordance with law. Right. Subject to the aforesaid form. So,
much obliged.
Serial number 25, my lord. I beg to appear for the appellant, my lord.
Yes.
My lord, I have filed a memo on 2022, my lord, stating that respondent R2 to 39 have not filed statement of objection, wherein they have filed, my lord. I may be permitted to withdraw that memo and file the statement filed by them along with all the documents, my lord.
Sorry, I was reading. Right.
You want to argue the matter or you don't want to argue?
My lord, I'm seeking to withdraw the memo which is filed stating that respondents have not filed their objection, my lord. Wherein it is they have filed an objection, I have to file those documents also, my lord.
She filed a memo. That memo she wants to withdraw. We're filing one more memo. Memo filed by the petitioner seeking withdrawal of the earlier memo is accepted. Earlier memo stands dismissed as withdrawn. Next, what?
I have filed those objection and documents, my lord. It may be taken up after vacation. I'll file the complete set
After
of
vacation.
They may be directed to produce the objection statement and the annexures filed by me before the learned single judge, which is not made the part of this paper.
You only produce it. ಏನು ಮಾಡಬೇಡ ಆಮೇಲೆ after vacation.
Director of a company which has borrowed financial assistance from the bank. Based on allegations that there has been defrauding of a complaint came to be presented in the state of Jammu against the bank officials and these. That case under the Corruption Act of Jammu and Kashmir is registered in the state of Jammu. Based on the fact that the provisions of the Ranabir Penal Code and the provisions of the Jammu and Kashmir Corruption Act has been invoked, authorities under the DMLA Act proceed to initiate action to attach my assets under Section 5 of the DMLA Act. The first, your worship, we go to page number 93. The relevant portion only for consideration.
Against this, you don't have any remedy?
Our major contention is Ranabir Penal Code or the Jammu and Kashmir Corruption Act is not an offence under the schedule to the PMLA Act. Now, whether to include those laws as a schedule offence or not is the decision of the government of India. The courts cannot by interpretation say that those laws are also included here. And none of the points that I have raised.
Request you to hear the matter.
Yes, you appear for.
So far as the challenge to provision attachment order is concerned, but page number 85, Not he has not an alternative remedy, not of approaching the appellate authority. Section 17 of the PML.
That is what we were asking.
That's number one. Number two,
whether there is any appellate authority.
There is. Section 17 mechanism.
17 provides the appellate authority whether it is functional. Whether it is functional or not.
Criminal is not functional. And question of going before the provisional authority, that is section 8, the adjudicating authority does not arise. The act does not apply to me.
That we will decide because the very applicability is under challenge.
Please, or in fact, may I just bring to logic and notice section 2, subsection 2, not of PML. It says not the Prevention of Money Laundering Act will be applicable in respect of the offences mentioned in the schedule. Or section 2, subsection 2 says any reference in this act or the schedule to any enactment or any provision thereof shall, in relation to an area in which such enactment or such provision is not in force, be construed as a reference to the corresponding law or relevant provisions of the corresponding law, if any, in force in that area. Now, Indian Penal Code is the corresponding, it is the law which not is in the schedule. Corresponding law to Indian Penal Code, not is Ranveer Penal Code.
That is to be considered. What?
Exactly.
That is to be considered by the court. What would be the corresponding law?
Corresponding. Then we should go back to the definition of corresponding law there in the definition clause or not run between.
Did you have the benefit of an interim order before the learned single judge?
No, no.
Because this was all that I am seeking is your lordship. Let the final order by the adjudicating authority not be passed pending consideration of this. Let the hearings be concluded.
Or that may be subject to final.
That order can be passed. No doubt. Order of the adjudicating authority is subject to not
the orders of.
Nothing. Heard learned counsel for the appellant and the learned counsel for the respondent and peruse the material. Learned senior counsel for the appellant. So on so. The matter requires consideration. Statement of objections to be filed within 4 weeks. List after vacation. Meanwhile, any steps, any order passed, any final order passed by the respondent pursuant to the impugned order dated
8/9/2021.
Meanwhile, proceedings before the respondent
adjudicating authority. No, not
can continue.
Shall be subject to
further orders to be passed by this court.
27.
Matters pertaining to notification regarding allotment of sand block, the non-shares of the area to the members of the SC/ST community. I was not allowed to participate only on the ground that I have not put documents pertaining to maintenance of stockyard. Now I have put a document for 38 cents, but rejection is allowed as per the notification resolution. First, may kindly present page number 56. Lord, page number 48. No such stipulation was there in the notification. There is nothing in the rules also, either under rule 31Y or 31ZBA. Only requirement is that, my lord. Page number 51 is relevant, my lord. See, they say, my lord, relevant portion is 50.
Application will hear it.
Yes, fine, okay.
File the statement of objection.
Yes, fine.
It's filed.
The only condition is.
We will hear it after vacation.
Please. The date can be.
Yes. Heard. It is informed that leasings have been exchanged and the matter can be heard finally. List on. Give it.
20 of Rule 32 of the KMMC rules. Because the matters are pending before the Honorable Supreme Court interim order, the High Court to be continued. Several petitions are pending here.
We will hear after the vacation.
Same interim order to be granted in these matters.
Rest in the month of July.
I pass on the SLP. I have already filed, but I
Meantime, the respondents may file their statement of objection. Statement of objection. Counsel for petitioner submits that the where is the interim order by the High Court? In the facts and circumstances, this court has provided in WP number 58505/2016 GMMS that after the pendency, the petitioner will be entitled to carry on quarrying operation, and the authorities shall issue permit upon payment of royalty as per the notification dated.
Not that was the then existing notification. Now we have revised the rate of royalty.
5/3/2014.
Existing rate of royalty. Yes.
The matter is also drawing attention court in SLP 773-788 of 2021. Learned AGA submits, Learned AGA appearing for respondent submits that the interim order passed in writ petition 58505 of 2016 is on the basis of the notification dated 5/3/2014. However, subsequently fresh notification has been issued. As an interim measure, it is hereby provided the list along with 58505 of 2016 and such other connected matters.
No, that was
now carried in
That has been carried to Supreme Court.
Yes.
and Honorable Supreme Court said same order to be continued. There are several matters.
Let's remove that in view of the fact that the apex court has extended the interim order passed by the High Court. We, as an interim measure, provide that the petitioner shall be entitled to carry on quarrying operation, and the authorities shall issue permit upon payment of royalty as per the existing notification. Just in the month of July, that has come from. Just in the month of July.
29.
In this matter, I appeal for the respondent too. I need to file my objections, Madam.
If this is approved, he will carry out the work of.
Yes, what are your instructions?
Well, yes, there is a job code created. Now, civil work has to start. So after the civil work, horticulture department will lay the lawn and beautify the place. After that, electrical work needs to be done.
You file the plan?
What?
You submit the plan which is there.
Yes, I'll submit a plan.
Mr. Srinidhi, and a counsel for respondent number 3. Praise was allowed 2 weeks time to submit the plan to develop the plan which has been approved to develop the area on either side of Kaveri pipeline passing through Vasant Ballabh Nagar, list in the third week of June.
Notice not is issued based on which survey which they say that they have conducted. But my only contention is opposed to natural justice without even reference to me. And they themselves in the final order at page 228 say it is difficult to find out what kind of, kindly see 228 for a second. And in the lead that presently, quarry lease number so has been executed for a period of 2.5 years with effect from 2/3/21 over an extent of 7 acres. So on. So currently, the quarrying operations is being conducted. Accordingly, it is difficult to determine the quantity of building stone quarried presently and prior to the sanction. They are confused, my lord. What is this? Whatever is the inquiry or the joint survey they want to do, let them give me an opportunity and do it is all that I am requesting in this and the next matter. Give me notice, do that. In the next one, I have even given a written representation saying, please do it in my presence.
Seek instruction whether any opportunity has been given.
It has been given. That in page number 224. 24, page number. Last time. As such, the Deputy District Commissioner, Deputy Superintendent of Police, Srirangapatna Subdivision, Rainforest Officer, Srirangapatna so Deputy Director of Land Records, Survey Department, in presence of the applicant, has taken up the survey work of notified area on 24/2/2021, has conducted the total
Get instructions. That's what he says. The contention is he's not been notified.
Not notified and earlier because the minister says
Instruction, mere presence is not sufficient.
Right. Learned AGA seeks time to obtain necessary instructions whether the petitioner was notified prior to survey work being conducted on 24/2/2021.
Whether any opportunity has
And
been given
notified and whether any opportunity was given to the petitioner
before issuing the
before
impugned demand notice.
Before issuing the impugned demand notice. Learned AGA accepts notice for response.
Give a date.
I will not all that I am doing.
There is an order passed by the authority. That alternative remedy is also there available to the
They make one respect. One respect.
Can dispose of the matter, treating it to be a show cause notice to him, and he may submit his reply and you pass a final order.
Or even my lord, the survey also I have no objection.
No survey notice is issued to him.
They not required.
No, that's what I'm.
Show cause notice Monday or that opportunity.
Because the minister said go and do it.
Tell us, if you treat it as a show cause notice, give 15 days time, we will provide to file the reply and pass a final order.
Yes, not in this matter.
Survey will not have to, in my presence, conduct, that's all
What?
I am requesting. Conduct a survey in my presence, I am subject to whatever.
Survey, then it will be difficult. Then that cannot. Now you file your reply to this, whatever you want, and let them pass a fresh order again. And in the this order shall be treated as the show cause notice, demand notice. We'll dispose of the matter.
Till such time as they take a fresh decision,
They will not do anything.
Not already we have filed.
That we will provide. That we will provide.
Already we have filed a criminal case against him for illegal mining. That is pending.
That is separate.
That is separate.
Or the London AGA appears for respondent 1, 2, and 3. The writ petition has been filed seeking following relief. Learned senior advocate appearing for the petitioner submits that the impugned demand notice has been issued in most arbitrary and illegal manner without providing any opportunity to the petitioner. It is contrary to the principles of natural justice and as such not sustainable in the eyes of law. Full stop. Learned ATA appearing for respondents submits that in case the contention of the petitioner is that no opportunity has been provided to him before issuing the impugned demand notice, then the impugned demand notice may be treated as a show cause notice to the petitioner, and the petitioner may file reply to the same, and thereafter a fresh order could be passed. In this view of the matter, the writ petition is finally disposed of with following orders. The number one, the order dated, impugned order dated such and such 2/3/2021. The next copy of which is next as annexure number Q. The petition shall be treated as a show cause notice.
And you,
Q and U, both two, both
Only use.
like Q and U shall be treated as show cause notices to the petitioner. Number two, the petitioner shall submit his reply to the impugned notice 2/3/2021 and 10/3/2022 within a period of 2 weeks from today.
just 4 weeks.
4
So I have to collect all the documents and submit.
All right, 4 weeks from today. Make it 3 weeks. 3 weeks from today. Number three, the senior geologist, who will decide?
Senior year.
This third respondent, senior geologist Mandya, shall thereafter, after considering the reply of the petitioner, shall pass a fresh order in accordance with law within a period of 5 weeks, within a period of 2 weeks. First off, number four, the no coercive action shall be taken against the petitioner on the basis of impugned notice dated 2/3/2021 and 10/3/2022 till a fresh order as proposed above shall be passed, is passed.
Hear me, my lord. Can I make a request? Give a reply and same day he can hear me. Because their documentation, I will make an oral submission also before.
3 weeks. Where reply, you have written 3 weeks for reply, and here the petition.
31.
No, it is not same, Lord. It is a case of violation of quarrying plan as well as in contravention of environmental clearance certificate. They have conducted quarrying operation and extracted illegally extracted 223 metric tons of silver.
There is this survey. I have given representations kindly and subject myself to any kind of a survey, and if it is found and repaired, kindly see.
Survey is not conducted.
And I have denied that anything is done in my presence with notice.
No. So cause notice was issued. Explanation was filed. He was present. And quantity was quantified, and moreover, Lord, this is an order passed by the Deputy Director of Mines and Geology. The revision lies against this order.
Yeah, I showed 3 orders in this on report. I have, my lord,
before they issue a show cause notice, they say we have conducted a survey from pit measurement, this is the violation. Now, while taking a pit measurement to know what is the quantity or whether I have extracted or not, should they not notify me and I should be present? My reply also says you have not done it. And this is what the Honorable Court in number of cases has said. It is violated. Without mere show cause notice to say you have removed it is not correct, is my respectful submission. Based on an alleged survey of pit measurement. While taking such a survey and pit measurement, should I not be notified and should I not be present when they are taking it? How should I know what is the kind of measurement they are doing? What's the kind of a survey? Technical report comes today, next day they issue the notice and not.
do a survey.
And kindly see, my lord, my own request. Request.
Conduct a survey again in his presence after notifying him.
Given an undertaking.
In this case, we have one lot, we have issued notice.
Where is that? Where is
In the implement order itself,
where is that? Please show us.
show cause notice was issued
Not show cause notice.
and he has replied.
Not show cause notice.
He has participated in the survey, kindly show.
You notified him on the date of the date of the survey. He was present on that day. Is that an admitted position?
No, that I will find. There was a technical report also submitted.
They are not concerned with the technical report. Kindly show that he has participated in the survey.
That
Completely, I have given an undertaking. Do it in my presence. If it is found to be any violation, I'm avoid.
As the same order, you conduct the survey also in that. In that same order, this only the orders dates will be changed. Include one more condition that impugned demand notice shall be treated as a show cause notice. Second point, that a survey shall be conducted by the respondents in presence of the petitioner of the which area?
Subject land.
Of the subject land within a period of 3 weeks from today and thereafter. Third point would be the second point, the reply would be filed by the petitioner within 3 weeks thereafter. Correct,
I'll do.
This one more condition is to be added at number 2. Same.
In fact, in both, they'll have to conduct resurvey. That is the contention.
In the other one also, if you
it
say,
is the same petitioner, isn't it? So conduct survey in both after notifying them and in their presence.
Put this condition of survey in both the cases.
Both.
The counsel for petition inform their matter is to be heard finally on a request agent list in the month of July. In the first week of July. June, senior advocates don't work.
I appear for the petitioner, my lords. My lord, there is no inspection report in this. Therefore, under 8B, and therefore the petition would not survive.
No giant.
So I may be permitted to. I may be permitted to withdraw the petition, my lord.
Not a saved application.
Not a saved application as produced.
With my lord's permission, I may be permitted to withdraw the petition, my lord. I will file an appropriate memo in the office.
Learned counsel for the petitioner submits that petitioner in this petition, petitioner is sought for the following release. After arguing the matter for some time, learned counsel for the petitioner seeks permission to withdraw the petition. Submission is placed on record. Petition is dismissed as withdrawn.
Grateful.
Application. Application you want to be passed over.
My lords, actually, there's an urgency in this matter, my lords. This appeal is filed challenging an order of AA, that is under section 9, my lords, we had filed an application seeking for injunction, my lords, restraining the respondent 1 and 2 from creating any third party rights.
One second.
Now, my lords, on the last occasion, my lords,
Matter had come up before us, is it?
there was a memo filed, my lords, producing certain communication.
2022 list on
14/6. My lords, urgency, my lords, is if it's listed after vacation, third party rights will be created, my lords, on the last.
whatever is done, that is subject to further order.
On the last date, my lords,
After the improved order, we wanted to pass an order. One second. We wanted to pass an order against us. With respondent number 3. Therefore, we said the impugned order was passed. So impugned order was passed by the trial court. Subsequent that, before the appeal was filed, so and so is entered into a transaction. That's what they are doing it. Where is SkyTop now? They are served.
The SkyTops are served.
Right. You don't appear for SkyTop.
I appear for the first respondent. But
SkyTop.
SkyTop.
Do you appear for SkyTop also? No.
No, I don't.
So shall we'll say SkyTop to maintain status quo.
May I make this submission? If they are so much insisting, it may be posted tomorrow. Because he has some inconvenience.
Interim order against SkyTop will suffice.
Because I have produced one document. There is already a release order, lords. There is already a release order.
Having regard to the urgency pleaded in IA 3 of 22, the application is disposed of, reserving liberty in favor of the appellant to move the vacation bench for early posting. But tomorrow there's no bench. Tomorrow bench is not there.
I will cooperate. There is absolutely no compromise. 35.
35, give a date after June.
Give a date. Quickly. All disposed of applications. Applications are disposed of. Done. We have given dates.